1. A lawyer represents a plaintiff in a personal injury case. The defendant's attorney is the lawyer's spouse. Must the lawyer obtain informed consent from the client? A. No, because personal relationships do not affect professional judgment. B. Yes, because the lawyer's personal relationship could materially affect representation. C. No, unless the client asks about the relationship. D. Yes, but only if the case goes to trial. Two. A lawyer represents two business partners in forming a corporation. A dispute arises between them. What is the best course of action? A. Withdraw from representing both clients. B. Continue representing the more cooperative partner. C. Represent both, as long as the clients give informed consent. D. Seek court approval before withdrawing. Three. A lawyer is asked to represent a new client against a former client in a related matter. Under the ABA model rules, when is this permissible? A. Only if the former client gives informed consent. B. If no confidential information is at risk. C. If the lawyer believes the representation is fair. D. Never, as it is always a conflict. Four. A lawyer takes on a complex antitrust case but has no experience in this area. Which of the following is the best approach? A. Decline the representation. B. Accept the case and learn on the job. C. Associate with a knowledgeable attorney or study the area before proceeding. D. Delegate all work to a junior attorney. Five. A client repeatedly fails to respond to a lawyer's requests for information, causing delays in a case. What should the lawyer do? A. Withdraw from representation. B. File motions without consulting the client. C. Continue representing the client without further communication. D. Seek court permission to sanction the client. Six. A lawyer agrees to handle a matter for a contingency fee but then fails to work on the case for over a year. What rule has been violated? A. Competence. B. Diligence. C. Communication. D. All of the above. Seven. A lawyer learns that a client intends to commit perjury. What should the lawyer do? A. Disclose the information to the court. B. Withdraw from representation without explanation. C. Do nothing, as client confidences must always be protected. D. Try to dissuade the client but not disclose unless perjury occurs. 8. Under the ABA model rules, when may a lawyer disclose confidential client information? A. When necessary to prevent reasonably certain death or substantial bodily harm. B. Only if required by a court order. C. Never, unless the client consents. D. Only after terminating representation. Nine. A lawyer discusses a client's case with another attorney at a bar, using names and details. What rule has been violated? A. Duty of loyalty. B. Confidentiality. C. Competence. D. None, if the lawyer believed the conversation was private. 10. A lawyer receives a settlement offer but believes it is too low. Can the lawyer reject it without informing the client? A. No, the lawyer must consult the client. B. Yes, if the lawyer believes it is in the client's best interest. C. Yes, but only if the retainer agreement allows it. D. No, unless the lawyer has written authorization. (11) A client asks a lawyer to help structure an illegal business scheme. What should the lawyer do? A. Provide advice on how to avoid detection. B. Withdraw from representation. C. Report the client to authorities. D. Draft legal documents but refuse to advise further. (12) Under the ABA model rules, which of the following lawyer advertisements is most likely to be improper? A. We win 90% of our cases. B. We have 20 years of combined experience. C. Call us for a free consultation. D. Top-rated attorney by an independent legal ranking service. (13) A lawyer directly approaches an accident victim in a hospital offering legal services. Is this allowed? A. Yes, if the client is in need of representation. B. No, as it constitutes improper solicitation. C. Yes, but only if the lawyer does not charge fees up front. D. No, unless the lawyer has a personal relationship with the victim. (14) A judge is hearing a case where one of the attorneys is the judge's sibling. What is the best course of action? A. Disclose the relationship and continue hearing the case. B. Recuse from the case. C. Rule in favor of the opposing party to avoid bias. D. Continue hearing the case if impartiality can be maintained. 15. A judge is running for election and personally solicits campaign contributions from lawyers. Is this permissible? A. No, Judges cannot personally solicit funds. B. Yes, if the lawyers appear before them regularly. C. Yes, if the judge discloses all contributions. D. No, unless the jurisdiction allows it. (16) A lawyer charges a contingency fee in a criminal case. Is this permissible? A. Yes, if the client agrees in writing. B. No, contingency fees are prohibited in criminal cases. C. Yes, as long as the fee is reasonable. D. No, unless the lawyer also charges an hourly fee. (17) A lawyer receives a settlement check for a client and deposits it into the lawyer's personal account before transferring the client's portion. Has the lawyer violated any rules? A. Yes, this is commingling of funds. B. No, as long as the lawyer transfers the funds promptly. C. No, if the client has given prior consent. D. Yes, but only if the lawyer uses the funds for personal expenses. (18) A lawyer agrees to represent a client for a flat fee but does not explain that the fee is non-refundable. Is this ethical? A. No, lawyers must clarify the terms of the fee agreement. B. Yes, if the fee is reasonable. C. No, unless the client asks for clarification. D. Yes, if the lawyer has already done significant work. (19) A non-lawyer employee at a law firm gives legal advice to a client without the lawyer's review. What rule has been violated? A. Competence. B. Unauthorized practice of law. C. Duty of communication. D. No rule has been violated. (20) A supervising attorney fails to correct an associate's legal error that harms a client. What is the best description of the supervising attorney's responsibility? A. The supervising attorney is responsible for ensuring competent work. B. Only the associate is responsible. C. The supervising attorney is responsible only if the associate is new. D. The supervising attorney is never responsible for subordinates' mistakes. (21) Can a lawyer assist a non-lawyer in drafting legal documents for others? A. No, because this would be aiding the unauthorized practice of law. B. Yes, if the non-lawyer does not sign the documents. C. Yes, if the lawyer reviews and approves the work. D. No, unless the non-lawyer is a law student. (22) A lawyer knowingly submits false evidence to a court. What is the best course of action? A. Withdraw from representation without explanation. B. Correct the false evidence, even if it harms the client. C. Do nothing, as client confidentiality prevails. D. Only correct the evidence if opposing counsel objects. MPRE. The Multistate Professional Responsibility Examination, or MPRE, is a standardized multiple-choice exam administered by the National Conference of Bar Examiners, or NCB, to assess a candidate's understanding of professional conduct for lawyers. The exam is required for bar admission in most U.S. jurisdictions and is based on the ABA Model Rules of Professional Conduct and the ABA Model Code of Judicial Conduct. It consists of 60 multiple-choice questions, 50 scored and 10 unscored pre-test questions, and is administered over 2 hours. The MPRE evaluates an applicant's ability to identify ethical issues in various legal scenarios, covering topics such as conflicts of interest, client confidentiality, judicial ethics, advertising, and professional misconduct. Unlike the bar exam, which tests substantive law, the MPRE focuses solely on legal ethics and professional responsibility, ensuring that aspiring attorneys understand the ethical obligations necessary for practicing law. Here are 5 top beneficial uses of MPRE. 1. Ensures ethical competence. The MPRE tests a lawyer's understanding of ethical rules and professional responsibilities, ensuring that they can navigate ethical dilemmas and uphold the integrity of the legal profession. 2. Requirement for bar admission. Most U.S. jurisdictions require passing the MPRE as a prerequisite for obtaining a law license, making it a critical step toward becoming a practicing attorney. 3. Promotes public trust in lawyers. By ensuring that attorneys understand and adhere to ethical standards, the MPRE helps maintain public confidence in the legal system and the fairness of legal representation. 4. Prepares lawyers for real-world ethical challenges. The MPRE presents scenarios that lawyers may face in practice, such as conflicts of interest, client confidentiality, and professional misconduct, helping them develop ethical decision-making skills. 5. Reduces risk of disciplinary actions. Lawyers who understand and apply ethical rules effectively are less likely to face disciplinary actions, malpractice claims, or disbarment due to professional misconduct.